Estate planning. The thought of losing your parents or relatives is not a pleasant one. If their wishes aren't discussed beforehand, there are a lot of legal and financial messes that you'll be left with. You could potentially lose money or assets as a result. That's why it's important to have a discussion with your parents about their estate plans openly and early, while your parents can make these decisions for themselves and tell you what they want. After some small talk, ask them, do you have an estate planning professional, or do you need help connecting with one? Regardless of how complicated your parents' situation is, they want to make sure that their wishes are recorded and carried out correctly in accordance to legal requirements. It's always wise to speak to an attorney and/or financial advisor for guidance. When it comes to proper estate planning, make sure beneficiaries are on all accounts and legal documents are in place, as this is crucial. Beneficiaries, you'd want them listed on bank accounts, investment accounts, potentially your home, as this will allow you to have things go directly to whom you want and will avoid probate. A couple of things to be careful of when adding beneficiaries to your home is potential creditors, as if the person you add has debt issues, the creditors then can take your house. You may also want to make sure you list someone that wants your home. When it comes to legal documents, we'll discuss wills and power of attorneys. The main purpose of a will is to make two designations. 1. The recipients of your property after your death. 2. Whom the executor will be, the person who will administer your estate when you're gone. While you're alive, you should have a couple documents in place as well. A durable power of attorney. This allows your parents to choose someone to act on their behalf in financial matters if they become physically or mentally unable to do things while alive. Healthcare power of attorney, or living will. Just like the durable power of attorney, this designates a trusted person to take care of financial matters. A health care power of attorney allows someone to make decisions about medical care. For example, they can authorize life support, hydration, medical treatments, and make health care decisions for your parents if they are incapacitated. The one thing that you want to be sure of, though, is that this person should know your parents' wishes and be trusted to carry out these plans. Your parents could potentially also have a trust. A trust would allow your parents to manage their property and designate someone to manage it for them after their death. There are two types of trusts: revocable, where they can change, and irrevocable, which they can't. Again, speaking with an attorney regarding these matters is very important. The last thing that you want to make sure of is that if your parents have taken care of all these particular documentation, you know where they are kept. Because again, even if your parents have taken the steps to establish the will, create other estate planning documents, compiled their financial statements, kept a record of their accounts, their assets, their debts, their passwords, and other sensitive information, if you don't know where that stuff is, it's not going to do you any good. If we can be of help with reviewing you or your parents' estate planning documents, let us know.